My lord, the response, government authorities are violating your lordship's order. So I am praying for listing of a pending content on 23rd or 26th as per your lordship's order.
Okay.
Lord, I am praying for listing of this matter. Matter relates to non-payment of arrears salary of the petitioner. The matter was last listed before Lordship's Court on 6th of January 2025, where the respondents are required to file affidavit. They have not filed the affidavit.
23rd.
23rd minute of line.
Give it a look. Also, I recommend for listing. Madam. Any date next week?
Okay. 28.
But is your lordship, I beg to mention for listing of two company petition for orders, lordship.
Okay. 26.
Orders, lordship.
May please your lordship, I beg to mention one writ petition for listing. Kindly for listed any date of next day.
28.
I love your lordship. I'm praying for listing of content matter for orders lordship. Next week lordship.
28.
Lord, I'd like to mention item number 15, my lord. Can it be taken next week, my lord? Because I'm appearing on behalf of Mr. P. Sharma, the London Council, my lord.
Item?
15.
Oh.
My lord, his brother expired, so he could not make it to the court today. My lord. Highly appreciate.
May I please, your lordship? Lordship, I beg to mention two repetition for motion for Monday, my lord. The urgency is that, my lord, this is the matter relates to appointment under 3F, my lord, and by an lordship's order, similar persons has been given direction to be appointed under 3F, my lord. And it is expiring on this week, my lord, the term. That is the urgency, my lord.
Why do you come so late? Oh, thank you.
Monday.
Perhaps, lordship, I get to mention a repetition for listing. It is for admission, lordship, similar. The issue relates to already such issue was decided by this honorable court.
Okay, 23rd.
All right.
I prefer adjournment on item number 18 of today's case. My senior is out of station, your lordship.
Who's your senior?
My senior is senior counsel, Mr. P. Pathak. He's out of station. Let the matter come after 2 weeks. If he doesn't appear, I will appear, your lordship.
Highly obliged.
May it please your lordship. Lordship, I beg to mention for listing a repetition for motion on 23rd, lordship. Oblige your lordship.
Item 1, motion.
Well, here our affidavit is ready. Well, today we will, during the course of the day, we will.
You are filing it.
Well,
Why is it coming for motion? Notice was issued the other day. Okay.
our affidavit is ready.
How to start? P. Google. P. Google. I'm request my parents to PK photo. When do you want? Let me take some. When do you want? When are you filing it?
I have no question. Well, next week, today we will file. During the course of the day, we will file.
Okay, then I consider Mr. PK photo. Then standing of the. It should be fixed on 2nd of May. The 2nd of June, sorry.
Item 2.
Oblige you.
Obliged. Please, your lordship. Lordship, I have talked with my clients. Lordship, they humbly pray before lordship to grant last opportunity so that they can produce relevant materials.
What can they can put this court grant? You have to, if you want to, sometime you have to approach the state level.
Yes, lordship. He will approach lordship. In fact, he has filed a representation in terms of the order dated 28/3. Lordship. However, lordship, the respondent SLSC, they have not taken any decision. Lordship, I am not lingering, lordship. I humbly pray before lordship that since it's a girl child, undoubtedly, lordship, the father of the petitioner, the girl child has committed a mistake, lordship. But is that mistake, lordship, is so grave that it will directly lead to cancellation of our admission. Lordship, they will appear before the committee. They will produce the relevant materials. If it goes
years
against,
too late, your lordship.
if it goes,
This prayer ought to have
Because-
been made last year in January,
because
February.
because
might have
the
been
order dated
considered.
5/12 and the 28/3/25 passed by this honorable court has merged with the order dated 5/12. And the order dated 28/3 has been
What 512, what
5/12/23
23?
is the judgment and order passed by this honorable court directing the petitioner to approach the state level cost scrutiny committee. However, Lordship, undoubtedly they did not.
It starts at
Yep.
page 18, your lordships. Page 18 it
In set
starts.
54, Lordship. The relevant portion, your Lordship, will find paragraph, it starts from 30. Paragraph 30,
Page 14.
page 47, Lordship. May I kindly read this, Lordship? Lordship, in the order of division bench dated 1910, paragraph 30 of the said order, Lordship. In the order of the division bench dated 1910/2023 in writ appeal number 390/2023 and other appeals, a further view was expressed that the new criteria of verification of producing evidence from the tea garden management was introduced, which had led to a travesty of justice being committed. The provisions thereof as to what the state level cost scrutiny committee is required to do is provided under paragraph 13(5) of the judgment rendered by the Supreme Court in Kumari Madhuri Patil Supra. 31 in paragraph 13(5), it is provided that the directorate is required to constitute a vigilance cell consisting which shall examine the parent guardian or the candidate in relation to their caste or such other persons who have knowledge of the social status of the candidate and then submit a report to the directorate together with all particulars as envisaged in the pro forma, in particular the scheduled tribes relating to the peculiar anthropological and ethnological traits, deity, rituals, customs, mode of marriage, death, ceremonies, method of burial of dead bodies, etc. by the caste or tribes or tribal communities concerned, etc. Then your lordship will find the relevant paragraph at page 51, 37, paragraph 37. 36. The respondent in the Social Justice and Empowerment Department also take note of the provisions of the law laid down by the Supreme Court in paragraph 13(1), 13(3), 13(6), and 13(5) of the 13(15) of the judgment rendered in Kumari Madhuri Patil Supra, and it is expected that the constitutional requirements would be duly complied with by the department. 37. In the facts of the present case, as it is a writ petition seeking for a direction for issuing the social status certificate to the petitioners, we accordingly require the petitioners to make an application to the revenue subdivisional officer or deputy commissioner, as the case may be, as provided in paragraph 13(1) of the pronouncement of the Supreme Court in Kumari Madhuri Patil Supra, and upon such application being made, the prospective revenue subdivisional officer or the deputy commissioner to give a due consideration to such certificate, make a factual determination on the entitlement to the social status as may be claimed, and if it is in respect of a social status under entry 24 of the notification dated 1993, to also undertake the necessary exercise of arriving at a factual determination as to whether the person concerned or any of the predecessors was a laborer in any of the tea gardens in Assam. Such certificate that may be issued would be subjected to scrutiny by the state level cost scrutiny committee by scrupulously following the complete procedure laid down in paragraph 13 of the judgment rendered by the Supreme Court in Kumari Madhuri Patil Supra. 38. We have also taken note that the petitioners are being admitted in the respondent Navodaya Vidyalaya by virtue of Lordship.
Page 56.
Lordship, page 56 is the show cause notice issued by the respondent school. 57 is the Lordship
Reminder.
reminder, Lordship. They say the respondent Navodaya say that Lordship, the certificate, caste certificate issued, submitted by the petitioner, which is issued by the All Assam Other Backward Classes Association and countersigned by the deputy commissioner, is not valid certificate. Lordship, in page 59, since he couldn't, there was a mistake, Lordship. Apparently, there was a mistake by the petitioner's father that he did not go before the committee when the committee said. Lordship, thereafter, Lordship, we approached this honorable court at page 60, Lordship. Paragraph 4. In view of the submission made by the counsel for the petitioner, there is nothing to be adjudicated in this petition. However, in the event the petitioner submits a representation before the state level cost scrutiny committee on or before 4/4/2025, the state level cost scrutiny committee should take a decision on the petitioner's representation expeditiously and not later than 30 days from the date of receipt of the representation. The petitioner shall also submit a proof of having enclosed the state level caste scrutiny committee to the principal PM3 school, Jawahar Navodaya Vidyalaya, Rifu, Karbi Anglong, on or before 4/4/2025. In the event of proof having approached the state level caste scrutiny committee is shown to the respondent number 4 on or before 4/4/2025, respondent number 4 should not act upon the impinged letter dated 28/2/2025 for a period of 1 month. Now, subsequently, after receipt of the certified copy of the order, we have already filed a representation before the state level caste scrutiny committee on 3/4/2025, before 1 day of 4/4/2025, the time limit provided in this order. But till now, no phone call, not a single intimation has been given to us by the state level caste scrutiny committee that he produced this material or that material.
On 3/4,
On 3/4,
where was that,
62.
committee meeting?
That committee meeting was in terms of the judgment and order dated 5/12/2023. That committee meeting held on 29/12/2023 and as well as 30/12/2023. They have already provided the minutes for your lordship.
Where's the minute?
A copy of the minutes has already been provided by the respondent.
Minute?
Yes.
That's of, 29/12/23.
Yes,
Yes.
in terms of the judgment and order dated 5/12/2023, the committee said, and they, if your lordship, I will just.
State level committee who approves.
Sorry,
Scrutiny committee.
Lordships, Mr. Aram Das is again out of station, I'm told, his junior is here.
Lordship,
Lordships, may I just submit one thing, Your Lordships? Yes, Your
the minutes, lordship,
I'll.
3 months in terms. That's the state level scrutiny committee has to be, but in 3 months. Okay.
Who's the here of Adam Das? Yeah, Sharma. Here, there was a direction passed by this court in the second writ petition. Directing the petitioner to approach the HLS. All right, I'm fixing a date. Now, the petitioner in terms of the judgment passed by this court, approached the HLS on 2/4/2025. Now, what happened after that? Anything happened?
Now I don't.
So, the one thing is that one side, someone is blocking an entrance of some other illegal. And on the other side, this is not 2/4/2025. The petitioner makes the representation before the SLA. Now, you have to tell her what you did after the representation. Yes, Scout.
Lordships, I would just like to point out one small thing for your Lordships. In the judgment which my learned friend is relying upon, this is Bijal Bora judgment. Therein, the directions of the Honorable Apex Court in the case of Madhuri Patil have been recorded. If I may take your Lordships to page 43 for a moment. Page 43 of the original application.
Yeah.
Clause number 9, your Lordships. Have your Lordships got it? May I just read it slowly? The inquiry should be completed as expeditiously as possible, preferably by day-to-day proceedings within such period not exceeding 2 months. If after inquiry, the caste scrutiny committee finds the claim to be false or spurious, they should pass an order cancelling the certificate issued and confiscate the same. It should communicate within 1 month from the date of the conclusion of the proceedings, the result of the inquiry to the parent or guardian and the applicant. Now, here is a case before your Lordships where they held the meeting on 29/12 and 30/12, and they were specifically given 1 month's time to go and appear. What stopped the petitioner from going and approaching the state level scrutiny committee at that point of time is a point which he has not explained anywhere. Now, after a year, he comes to court, he takes this innocuous order from this honorable court that I will once again approach the state level scrutiny committee. Today, he's saying on 3rd of May, we have submitted our application. Assuming that the state level committee gives him 1 month's time, he again does not appear. Again, he'll come back next year. Can that be a proposition of law, your Lordships? Will your Lordships continue to have this fraud which is being played on the court? This is a child who has taken admission on the basis of an OBC certificate. Now that you have never produced the OBC certificate before the authorities, and yet you have continued to study with us for 3 years. Can that be a joke? can this amount of fraud and how much more leverage are we going to give because it is a girl child? I completely understand. It is the career of a child, of a student. I would not have made this submission with very gravity, with full gravity. I'm making the submission that these kind of frauds which are being played on the court and on the authorities need to be strictly taken note of, your lordship.
I've taken note.
Yes, your lordship. I'm deeply obliged. I,
Only thing is, Sharma, you come with some instructions by Friday. Friday we are disposing of it. I'm not giving you what.
Lordship, considering the submission made by my learned senior, if he doesn't appear on the next committee sitting, then your lordship can very well cancel, or the committee can cancel.
That's a different issue.
Yes,
I think this court wants to know is after your representation that you have filed,
lordship.
what they have done.
Our Bora, lordship.
Our Bora should have also heard them with that stuff. Council, ABS,
envious,
NVA.
envious.
Stop, Mr. You're the standing council, no?
I'm appearing on behalf.
Mr. C. Shamal and count. Appearing on behalf of state level cost scrutiny committee. So, shall take instruction as to what step to take by the state council. After the representative was filed with the on 2/4 in terms of the order taken 28 to passed by the court. Please, matter or tomorrow is Friday? Yes.
Lordship, the representation was filed on 3/4.
Here it is 2/4.
Seal is on 3/4.
Okay, make it good.
You also may have it on Monday.
Monday will-
Monday.
But Monday,
Monday last, you know, so let them get the instructions positively because it becomes difficult for us. The new admission session will also start here there. Deeply obliged.
matter on 19th.
Obviously, lordship.
Lord, may I take the liberty to interfere, Lord?
Lordship, the interim order may be continued, lordship.
Till Monday. La. In any case, we're not doing anything right now.
It will
Alright.
make a difference. Anyway.
Milord, I'm coming from Kolkata all the way. Milord, a matter was listed in the court number 12, Milord. By the time I mentioned over there and coming back, I lost the time for mentioning over here. It's a very serious matter, Milord. I filed the case in the month of August, complaining against infringement of Article 14 and 16. I am the professor in NIT Silchar, Milord, and I am for the last 15 years in the same post, while my students, my juniors have been promoted. Now, Milord, I have already prayed for a stay. Milord, now they are going to again recruit.
No, what do you want? What do you want?
Milord, I am a professor in,
Is it listed today?
not Milord, it was listed in court number 12.
Huh.
Very unfortunate thing happened. My advocate, without instruction from his client, prayed for an adjournment for a long period. And we are taking up the matter with the bar and with the learned advocate. Milord, that is a different issue, Milord. For the timing, Milord, I would like to have this, have it listed tomorrow, Milord, if you kindly. If you not,
No, that order was passed in court number 12, isn't it?
I have been referred over here, Milord. I have mentioned it in court number 12, Milord. I have been referred to over a senior court. That is your court, Milord. And if you kindly list it,
Have you got a mention memo? Have you prepared a mention memo?
I'm afraid not, Milord, mention.
Prepared a mention memo.
That will be.
Item 3.
Yes.
One of this matter is the compassionate appointment, my lord. And the petitioner's father died on 2010-2008, and he applied on 7/3/2009, my lord. And I have annexed the DLC decision, my lord. DLC decision is annexure D, my lord. Page
39.
page 39, my lord. Placed in the DLC meeting complying Honorable High Court's order dated 28/6/2023, passed in WPC number so-and-so and decided to recommend.
Where's your name?
Name is Mukut Chandra Kaman, serial number 4 at page 39, my lord. So his name was recommended, my lord. Decided to recommend for LP school teacher under the
Then what happened?
of District Elementary Education Officer. Subsequently, my lord, this office memorandum was issued, my lord. And so because of that, my lord, it was not placed before SLC.
Do you have a copy of the orders passed by this court?
My lord,
You have a copy of the order passed by this court? Recently.
copy, my lord. I have not annexed, my lord, but I can produce, my lord.
Can you dispose of this matter?
Lordship, may I dispose of lordship?
To place it before the SLC?
Yes, lordship. Lordship.
You approved this court earlier?
Yes, my lord. Earlier, the petitioner approached this honorable court and there was a direction.
With the court's order.
Order I have not annexed, but I can produce it, my lord. At the break time, my lord. I'll furnish the copy, my lord.
How can we? How if you filed all this without court order?
My lord, copy is here, my lord.
This court's order,
Yes, my lord.
the first read petition.
First rate petition.
Let us.
3772. 2023.
23. 23, how much price?
Yes or not?
I'm downloading lordship.
Oh, 3772 is a very short order.
Yes, lordship.
To
Yes, lordship.
to place it before the deal.
Paragraph 3.
Because earlier it was not placed. That was my prayer earlier.
Okay, first MSFP order and the call.
We have an answer.
Also, yes, for what, government advocate
Lordship.
for the respondent, 1, 2,
1 to 3 and 1 to 3 and 6, lordship.
1, 2, 3.
Then-
MSFP and something called
4 and 5. 4 and 5.
elementary education department for the respondent for the order of the late Chapila. Amar. While serving as headmaster of Azadpur LP. Not left. Site design on 28. Draft the petition method application. For appointment of substitute on 7. Here in this writ petition, it's not 7/3/2009, it's 26/11/2012.
Date of application, my lord.
Paragraph
I have annexed the application. Date of application is my lord 7/3/2009, my lord. at page 27, my lord. 27 and 28.
However, as the case of petitioner was not considered by the concerned DLC, he approached this court by filing the petition of 3772 of which was disposed of by an order dated 28/6/2023, directing the district elementary division of Lucknow to verify the reports and the place the application before the concerned district level committee for consideration of case for upper law. The district level committee was also directed to consider the case of the petitioner on his in its next. Stop. The district level committee. Lucky. In its meeting held on 1/9/20, we commented the case of for appointment on compulsory club to a post of LP equal under the office of the district elementary school. Stop. For 10 by 20. MSS for what level? Document. Submit. That is the petition has already applied by finding that document. Please don't submit document. And further, as the district level of has recommended the case on 1/9. Was recommended by the district level of Lucknow on 1/9. And also taking into consideration the order dated 3/4/2025. Passed in the petition of 342. Public 2025. I mean, a paper. Other than the case of the account is understood by paper. Because district petition. Directing the sector to consider the case in its next. How it became that political, but the outcome of that was the conflict.
Item 4.
My lord, this matter also relates to compassionate appointment, my lord. Here I have annexed the earlier order of this honorable court at page 27, my lord. Relevant portion 28, 29, my lord. Direction is given.
When was the deal?
It was DLC at page 40, my lord. DLC dated 26/10/2023. Page 40, annexure B, my lord. And petitioner's name is at serial number 4. Then, my lord, thereafter, my lord, this office memorandum were issued, and that is why, my lord, his case could not be placed before the, my lord. SLC.
No, you may pass an order to place before the essential object.
First, let me just speak out. One, two,
3 and 6.
three, six,
4, 5.
The order of late. While serving as headmaster in the common local health school. In the district of on 18/7/2024. Thereafter, the petitioner met an applicant for appointment of funds on 59. However, in the case of the petitioner was not successful, despite the delay. The petitioner approached the court by sending the 4564. Which was the first one, but dated 13/9. Directing that the application of be placed before the next available period of the for application of for a district level former Lakshmipur in his meeting held on 26 April. Considered the case of and recommended for appointment to a LP ticket for a post of under the office of the district elected. Except that meeting minus 26.
Item 5, orders the vacating. Also, in this case, on the last occasion, day before yesterday, it was mentioned by the respondent regarding designability. Lordship, the objection as well as the affidavit in reply is not on record. I just checked it.
In the IA?
IA as well as the affidavit. Lordship, what I pray is that the whole matter can be disposed of. It's not a very big matter. It's just regarding transfer order. I'm challenging the transfer order on 2 grounds. So they have filed their objection. I have filed my reply. It can be disposed of. So on Monday, I just had a word with the senior. So Monday it can be listed and disposed.
Monday, many things are there. How about Tuesday on a hearing?
Tuesday, there is difficulty on part of my senior lordship,
Tuesday was
Senior?
PP Datta lordship.
Then how about Wednesday?
Lordship on
Lordship.
20 or 21st, 22nd, I'm in Itanagar, Lordship. That's the difficulty. So maybe
23rd?
23rd, Lordship, yes, because I'll be returning.
Can you consult with your senior?
23rd, I think.
Lordship, after some time, lordship.
Lordship, we'll give the date to the code master. Lordship will pass an order.
MS
P Sharma lordship.
P. Sharma, then the council appearing on behalf of PP Datta, then the council for the applicant. Submit that they have filed objections.
Oh, we have
not-
filed objections. It's the respondent, RJ Das.
Sorry, Mr.
RJ Das.
RJ Das, then the council for the opposite party number.
It's just saying he's a sole respondent, solo
Opposite party that he has filed objections on
8/5.
8/5/2025 in IA Civil 1247 of the.
I've also-
You filed your affidavit in opposition.
Yes,
Lordship,
yes, they have filed. And we have filed a reply also. Affidavit in opposition is on record. The reply is not on record.
IA has been filed by us, Lordship, for
No, that's it.
Mr. RD does the counsel for the petition. In WT 4669 of 2024 of the submit that he has filed accepting reply to be a affidavit in opposition filed by the
By
Respondent.
respondents, they are all the
by the
respondents.
respondents 1 to 3 same day
Same.
on 8/5/2025. We just need to verify and place the same of everyone on the 24th. This the matter on.
On-
You give the date.
Yes.
Lordship.
So deeply obliged. Lordship.
Much obliged.
Item 6, admission.
Lordship, Fukun is on Lakes Lordship, so actually with time being Lordship.
Item 7. Lordship, this is Parhat matter. Lordship has already heard the matter regarding utilizing of services of the petitioner for 20 years by paying only 416 rupees. Lordship. Lordship has already expressed Lordship mind regarding the
I have received some instruction, madam. So kindly sometime we will allowed to file our affidavit.
Lordship already affidavit is with some file, and against that we have also already filed our reply.
And we have to take, we have to take, uh, we have to take a stand on behalf of the director. So madam, kindly sometime may be allowed, because all those appointment orders was not received by the director of his firm. So kindly they have stated.
Who filed the affidavit? in
Director.
Lordship?
Post of Director of Elementary Education. He has himself filed this.
Director has filed the
Yes,
affidavit.
and it is not our case that he has issued the appointment letter. We have, our stand is that appointment letter, engagement order was.
About the letters which was received or not by the director, we have to take stand on behalf of the director.
Okay, heard Mr.
K. Kolita, Lordship.
Lordship.
Lordship, one my submission, Lordship. We have already in our paragraph 23, it is our stated that the said engagement order was marked to the director also. And against that paragraph, they have not stated anything. That means they have admitted. Now, after hearing this matter for some extent, they are now taking time, Lordship. It's a
Malad-
delay take this because several occasions the time was granted and accordingly they have filed their affidavit.
The
This is a
director
part
of
of matter,
his favor received all those engagement letters.
Okay.
All the action was taken.
For B. Sharma, and he also leaves. Respondent number 7, I can leave.
The P. Sharma and then the standing counsel.
Ma'am.
And then get a account. Oh, okay, take off. MS10 spoken, then the standing counsel and the page. It's allowed 1 week time.
2 weeks, ma'am.
Why 2 weeks? Is a part of matter.
Yes.
Okay. 10 days. ma'am.
It's allowed 10 days time. To file an additional effort. List on. You could wait.
3rd June.
My lord.
First, you know, many cases are good.
On a
5th
hearing-
June.
On a hearing date. Lordship.
You want it on a hearing? date?
Yes,
5th June.
as a part of Lordship.
Deeply.
File your Lordship. Item 9.
May I please, dear Lord? Lordship. Similar matter like this one, my lord, is pending before the court number 12, and it is on part her, my lord. So take the matter along with them, my lord.
Yeah, the order included in this case, there are 4 persons. I'm appearing for the one, and during the course, as it is fixed today for final disposal, in the meter 1/5/2025, the another for 3% who is there that came before the court number 12. And after that, the record is with this court, with the, in this case, and therefore the court had and part had the matter.
That is partner.
Oh, that is part of it. That is what I'm saying. This is Lordship, the right to registry, he take the matter along with this case.
And when is it listed?
It was listed
How
on
did we see?
1/5/2025.
It is fixed on when I take 22nd.
Mr. P.V. Baron. On request made by Mr. U. Sharma and the attending counsel, Secretary. Please this matter on
This one tag with that.
on
WPC number.
this matter on 22/5/2025. Along with WPC number 935 of 2025.
Item 10.
Well, petitioner before this honorable court is an assistant this my lord in the my lord Abdul Sattar LP school.
1 minute.
And first assistant is my lord, and for provincialization of the my lord, petitioner my lord, already my lord district my lord scrutiny committee district elementary
Affidavit has come.
lordship.
Affidavit has come.
Affidavit not possible.
Well, I'm waiting for my instruction, madam. Matter may take after 3 weeks, in the meantime, I will find 23 meter.
23 meter man.
And respondent number 8.
Service complete man.
Service complete, madam. They have entered it.
Seven and 8. They've also not filed the affidavit.
And not necessary, but only my lord I have already taken steps and they have also only government my lord.
On issues made by SPP and the standing council preliminary. Please the matter after 3 weeks.
My lord.
2 weeks my lord, 2 weeks.
3 weeks, my lord, because I have not received the instructions, my lord. That's why.
After 2 weeks, available.
That may be.
My lord. God bless you.
11.
Lordship, I was appointed as an assistant teacher. You will find at page 18, madam, annexure 1. Serial number 43, page 21.
Here, my lord, we have not filed our affidavit. My lord, I am yet to receive
Who
our
has filed the affidavit?
respondent.
My lord,
Respondent number 7.
yes, I have filed reply also, an additional affidavit, madam. An additional affidavit is also being filed, challenging the appointment of respondent number 7, madam. Just an amendment in the writ petition.
You are praying for amendment of the writ petition?
Yes, because at the time of filing of writ petition, we are not aware of his
No, no, no.
appointment, madam.
Can you amend your writ petition by way of an additional affidavit?
That cannot happen.
You have to file an IA. Making a proposal.
Praying for amender.
Just an additional pleading, my lord.
This is not an additional. You didn't lead your amendment. You want to change the course titles. You want to change your prayer portions.
Then in that case, my lord, let me withdraw. I will file.
Okay, I'll just keep it this one.
Yes, madam.
Okay. Mr.
DK Bakshi.
DK Bakshi and the counsel for the petitioner prays for withdrawal of the additional affidavit filed on 14 May 2025. And also further prays for how much time?
Well, 3 weeks.
3 weeks time to file an appropriate application for amendment of the petition. Where it's allowed. This application.
Bless.
12 and 13.
It is lost. My lord, I am appearing the item number 12, my lord. WC number 6.3.
Huyan, you have for?
Lordship, in item number 12, I am respondent number 5.
5.
And file, my lord, APGB in opposition.
And who appears for respondent 6?
My lord, in item number 12, my lord, I am appearing for respondent number 4 and 6.
Okay.
And I will file our affidavit.
You filed.
In fact, my lord, the department has also filed their affidavit, my lord, that Director of Secondary Education, my lord.
And how about in item 30?
13, my lord, I am, my lord, petitioner. And here, my lord, there is a order passed by this honorable court. The subject to outcome, this petition, the representation is to be allowed. And that our representation has yet not allowed. Because, my lord, so far seniority list is concerned, I am senior. And I am senior, my lord, and respondent number, item number 12, he is far junior to me. And I am senior, but I am depriving. I am not allowing to hold that in charge. And on the other hand, my lord, respondent number, item number 12, already holding the charge for official, my lord, in charge. During the pending of this suit.
No, pleadings are complete.
Yes, my lord. Now, my lord, in fact, my lord, even lordships go through the affidavit filed by the Director of Secondary Education, my lord. It may be disposed of, my lord.
All parties are ready?
Yeah.
Yes,
Yes, my lord. Here, my lord, the petitioner, my lord, of in the item number 12, my lord, 6213 WPC number. Here, my lord, he was initially appointed as an institute teacher, my lord, on 6/12/2019. Sorry, 1999, my lord, at Bhavanipur Higher Secondary School, my lord. Next, sir, A, my lord.
Okay.
My lord. What happened, my lord? Under the my lord, Institute School, Borbada District Circle, my lord. And he had joined the same post on 17/12/1999, my lord. It is.
Oh, who issued this order?
My lord, it was issued by the Inspector of School, my lord. Yes, my lord. Inspector of School, Borbada District.
Yes.
Then, my lord, subsequently, my lord, while he was serving in the same capacity, my lord, the respondent number 6, my lord, respondent number 5, my lord, that Parvananda
You are Sanjay
Das,
Kumar Taluka.
yes, Parvananda Das, my lord. Respondent number 5, my lord. The petition in other petition, my lord. He was initially serving in other school, my lord. My lord, subsequently, my lord, that person, my lord, was transferred to the present school, my lord, where the present petition is working, my lord. He was transferred on 31/5/2001, my lord.
Is this respondent?
Respondent number 5, my lord. Now, my lord, if your lordships go through the page 20, my lord, his transfer order, my lord, kindly come to page 20, my lord. Here, my lord, it is the order issued by the Inspector of School, Borbada District Circle, my lord, page 20, my lord. Order, in his own request, Sri Parvananda Das, Hindi teacher, my lord. In his own request, kindly note this point, my lord. In his own request, Sri Parvananda Das, Hindi teacher, Uttar Borbata High School is hereby transferred and posted at Bhavanipur HSC School in his grade and scale of pay with immediate effect against the post High Sri Rinanath, Hindi teacher transfer. He cannot claim the seniority over the existing staff of the school. No TADA will be admissible for the purpose, my lord. My lord, this is his own transfer order, my lord. Ultimately, in pursuant to the transfer order, my lord, he had joined, my lord, on 31/5/2001, my lord. Last will find his joining letter at page 22, my lord.
Transfer order also same date, 31/5.
Yes, yes, my lord.
Okay.
Now, my lord, if he had joined transferred, my lord, at his own request, my lord, he cannot claim seniority. It is the settled position of law, my lord. Subsequently, my lord, what happened, my lord, after the retirement of the existing principal, my lord, he had prepared a my lord, graduation list, my lord.
Who?
That principal, my lord, of that high secondary school, my lord.
showing that, my lord, the respondent number 5, my lord, he is senior than me, my lord.
Where is that?
My lord, kindly come to page 24, my lord. Your lordship will find at page 25, my lord. The relevant, my lord. Here, my lord, the serial number 3, my lord, is the respondent number 5, my lord, Parmananda Das. Page 25, my lord. This is the gradation list, my lord. And the petitioner had shown at serial number 4, my lord.
Yeah.
Despite of that, my lord.
Okay.
Now, my lord, at the time of his retirement, my lord, the earlier principal, my lord, he had issued this letter, my lord, page 28, my lord. Page 28, my lord. That seniority list, my lord, was submitted by the inspector to the Director of Secondary Education, my lord. Page 28. Submission of seniority list for placing a principal in charge of Bhavanipur HIS school, my lord. With reference to the subject cited above, I have the honor to inform you that the Anjan Kumar the Misra, that is in charge principal of Bhavani Kumar, will be retired from his service by superannuation on 30/6/2024. In this connection, he has submitted the seniority list containing 12 numbers of teaching staff for placing in charge principal of the said school. Therefore, I am forwarding this said seniority list to you along with related papers for favor of your kind information necessary action. Madam. Being agreed at the seniority list, my lord, the present petitioner, my lord, has submitted a representation before the Director of Secondary Education, page 29, my lord, regarding correction of seniority list in respect of the teaching staff of the Bhavanipur HIS school, Bhavata, submitted by the retired insert principal of the said school. Despite of that, my lord, that seniority list was not corrected. However, my lord, the petitioner was allotted, my lord, to look up the academic aspect of the school for smooth functioning of the classes until further order, page 31, my lord.
Who is this? Ashok Das?
Now, my lord, subsequently that order has recalled, my lord, and subsequently Ashok Das, my lord, that is the, he is presently holding the in charge of the in charge principal of the state school. This student number.
Okay, page 31 is your.
31 is mine, my lord.
Hmm.
Therefore, that was modified, page 32, my lord. And the student number 6, my lord, that is also the student 4, my lord, the in charge principal. He was interested the SARS. Ashok Das.
Respondent 6, Roy, you are representing.
Yes, my lord, I am appearing 4 and 6.
Okay.
Now, my lord, your lordships come to their affidavit, my lord, filed by the Director of Secondary Education, my lord. Kindly come to page 35, my lord, of the affidavit in opposition, my lord. Paragraph 5, my lord. May I read, my lord?
Yeah.
Yeah, my lord, paragraph 5, my lord, page 35, my lord. That the answering deponent humbly begs to state that the respondent of 5, that is the Parmanand, that is Sri Parmananda Das, respondent of 5, my lord, who received graduate scale of pay with effect from 12/12/1997, was transferred at his own request, my lord, from Uttar Barpata High School to Bhavanipur HSC School by the then Inspector of School Barpata by order number so dated 31/5/2001, wherein it is mentioned in the said order that he cannot claim seniority over the existing staff of the said school. Therefore, his seniority in the Bhavanipur HSC School is to be counted from the date of joining in the Bhavanipur, that is 4/6/2001. Ultimately, my lord, he is not in the zone of consideration, my lord. Subsequently, my lord, kindly come to paragraph 6, my lord, that the answering tribunal humbly begs to state that on detection of misconduct for violation of Rule 13 of the Assam Civil Service Conduct Act 1965, due to not obtaining prior permission for acquiring his MA and BEd during his service period, that is 1998 and 2015 respectively, the Inspector of School Barpata has already initiated developmental proceeding against the respondent number 5, Sri Parmananda Das, who is pending. Ultimately, my lord, there is nothing, my lord. He cannot be senior more than over me, my lord. And I am the most eligible now. I am the most eligible candidate, senior most candidate. So, my lord, till the regular principal is appointed, my lord, I may be hold the complete full charge of the principal of the city school, my lord. And moreover, my lord, the affidavit, my lord, filed by the decimal number 4 and 6, my lord. Page, it is started from page 50.
This is the report of the inspector of school.
Yes. Well, it's, as your lordship has already gone through the page 42, my lord. This is the report, my lord. Here, my lord, this is to speak, my lord, there that I am the senior most and eligible candidate, my lord. Page 42, the inquiry report, my lord. Last paragraph.
What is the meaning of this? This last para?
Next up, please, address portable. Yes, sir, as one of senior teachers, the one on the assistant teacher. As the departmental counselings under office against the white office letter number 12, that is 11/7/2020. Therefore, undersigned allowed Honorable Mark Calendar, the present petition. Honorable Mark Calendar, who is also a senior teacher as per gradation is committed by then principal of the said school to look after the academic affairs of the school by office order memo 22 dated 1/3/2025 for the smooth functioning of the school and the office earlier order by memo number 72 hereby cancelled with immediate effect.
Okay, then that Ashok Das. Isn't that Ashok Das? Yeah, this order was cancelled.
Yes, my lord.
And now you are the in charge.
They have
It's the academic side only.
Oh,
Financial side is on the hand of the inspector.
okay. So now you are having the in charge.
I have not yet taken over the charges. But no, not financial charge, only academic.
Have you taken over charge?
Yes, ma'am.
The order.
Only academic, ma'am.
Order itself, it is a matter page 46, annex of 4. For smooth functioning of all good activities of Bhawanipur Regional School, Stonewall Talukdar assistant teacher of Bhawanipur Regional School is hereby allowed to look after the classes of school as well as academic side with immediate effect until further order. This office earlier order by memo number 12 dated in Kolkata 6/70/2024 is hereby sanctioned.
But this affidavit has not provided 6213. This affidavit has yet not furnished.
Furnished to you?
Yes, yet not produced. So respondent number 5 is concerned.
So far as you are concerned, your writ petition has become infected.
Because he has also allowed.
No, ma'am, only academic charge was given. No financial.
Earlier also you were given academic charge only.
Earlier was there, madam, because there is a dispute in seniority, madam. Now that part is over, madam. Because I am the most eligible and senior most teacher, madam. So, madam, I'll be given full charge, full in charge.
Vian, have you received a copy of this?
No. Yet not provided. And so far, my lord, prayer is concerned, it is infectious because already holding the charge as the academic charge. So prayer is concerned, my lord.
Because, my lord,
Prayer,
I have
so
to
far
run the
prayer is
school, madam.
concerned. And I have, my lord, filed affidavit in opposition against his petition number 6213. My lord, kindly have a look, lordship. And this transfer, my lord, after, my lord, 1982 rule, my lord, after 1982 rule. So this is governed by 1982 rule, which do not contemplate loss of seniority on request transfer. Because transfer was held on 31st of May 2001. So 2003 rule is not covered.
See your prayer.
Infectious. His petition is infectious.
Yes. Almost all prayer, my lord, allowed, my lord. There were only
Instructions with it, this has become.
my lord,
There's no point of hearing the matter.
my lord.
You're already out. Yes, you're already out.
But so far my prayer is concerned,
So far, the other writ petition is concerned, that we'll have to consider on it.
and so far item number 13, my lord.
Oh.
My writ petition there made, my lord, regarding the seniority. And I relied upon, my lord, rule.
1 minute.
Here.
Here, my lord,
1 minute.
transfer on 31st of May 2001. So, rule 1982.
When even your writ petition is now become effective. You have to implement it.
No, he already holding the academic insurance. And my prayer is, my lord, insurance of principal.
That's why.
And my prayer, my lord, quite different. And in this case, Lordship, kindly have a look, my lord. Allow the petitioner to hold the charge of principal.
Correct.
And he is holding the official academic insurance. And and charge of principal holding by the inspector of school. Still, my lord, respondent number here, my lord, respondent number 3, holding the charge of insurance, still. And so far item number 12 is concerned, he is holding the academic insurance, not charge of insurance of principal. So issue is quite different. And so far my transfer is concerned to the same post. So if same post, prior to, my lord, 2003 rule is not covered. So rule, my lord, 1982 rule, my lord, saying. 1982 rule, my lord. Rule 13 is followed.
That's whether the. 1 week time.
Right.
Is the matter after 1 week.
Well, in item number 13, well, I have not included as a.
You are not a part.
Right. So if he wants to may.
No, he was not confirmed because he's far junior. So no, he was not made part.
I have to.
We'll have to think about it. Whatever it is, he's now given the in charge of his classes in the academic side. Now, if you want to become a principal in charge, you'll have to get all those.
Yes.
Correct.
I will make party.
That is
I will make party.
in the petition number
4903.
4903, you wrote, Mr. S. K. Boyan, non-constituted. Praise for filing an application for improvement of this other one. One week will do half.
My lord, I will obtain statement.
Within 1 week you can do it.
My lord, affidavit filed by the government has yet not furnished me.
Sharma, you furnish it.
So I will file reply, my lord.
In the that Mr. Sharma, understanding council, secondary education department, and Mr. P. Royal,
I will file reply, my lord. So far, repetition 6213 is concerned. Reply against affidavit.
That you can. You can. You
Hello.
have to list.
Hi, Lord.
Item 6.
Other day, the university council is sought for time to clarify on a particular judgment laws. Otherwise, the argument is concluded.
Lord, the matter, the issue before your lordship is regarding NOC, that NOC aspect. The private respondent number 8. 8 has not been issued any NOC by the college concerned. So that is the issue before your lordship. My lord, if I turn to the KK Hendrik State Open University Act. First the legal provisions, then I'll, my lord, place the authorities. My lord. Ordinance number 8, page 126 and 127. Down below the page marks are there. 126 and 127.
This is what ordinance? KKNT Corporate.
My lord. And the ordinance has been framed under that act. My lord. So it starts from page 126, the heading. My lord.
Ordinance start from page.
That ordinance number 8, my lord.
Oh.
126. It is framed under section 23 1D of the Act. Act means that KK Hendrik Act. Ordinance on recruitment. This is important, my lord, that heading. Ordinance on recruitment, service condition, workload, and leave rules for professor, reader, regional directors, lecturers, and so of the university. Now, next paragraph. No person shall be appointed in any of the posts mentioned below without fulfilling the requirements mentioned against each such post. So it has been clearly, my lord, provided that no person shall be appointed. So there are two categories: one essential qualification and another desirable qualification. Now we can turn to page 127. Clause 3. We are concerned about this lecturer, assistant professor, essential.
3.
Clause 3.
Ordinance 2. Ordinance 3.
Page 127. Clause 1 is regarding professor, clause 2 regarding reader, and clause 3 regarding lecturer. These are essential qualifications. Consistently good academic records with at least so and so equivalent grade of B in the 7-point scale with letter grade so and so, master degree level in the relevant subject from an Indian university or an equivalent degree from a foreign university. 2. Besides fulfilling the above qualifications, candidates should have cleared the NET for lecturers conducted by UGC, CSIR, or similar tests accredited by the UGC. These two criteria, Miller, are essential. Without these two criteria, Miller, fulfilling these two criteria, no one could be appointed by the university authority. Now, second, desirable. It is only desirable. It is not essential. Degree, diploma, experience of working, and working knowledge of computer. Number 2, that experience of working. Since we are concerned about NOC, so I am stressing upon that clause 2, One is regarding degree, diploma in distance education. Second, experience of working in Open University distance education system. And 3, working knowledge of computer. Provided that a relaxation to a requirement of NET marks at master's level or any other requirement shall be as per UGC guidelines circulated for the purpose from time to time. So, regarding NOC, that 2 will be applicable, but it is desirable. Whether that
ODL is only desirable.
Desirable. So, my argument will be on the basis of this, whether that NOC, requirement of NOC is mandatory or optional or directory. Since it falls upon the desirable category, so, this is not mandatory. If we skip other para and kindly turn to page 129, notes. Page 129, in the middle portion, the notes. We can skip 1, 2, 3, 4, also 5. Now 6, next page. Page 130. The PhD degree will be a compulsory requirement for the designation of reader. However, for other categories, like those of registrar, librarian, director of physical education, and the equivalent posts, the PhD degree shall be desirable and not an essential qualification. So, my lord, that essential and desirability aspects have been little bit explained in this note. If it is essential, that PhD is essential for reader, but for other equivalent posts, PhD degree is not essential, only desirable. So if we now come back to that lecturer essential and desirable category, then it is only optional, that NOC. Now, when we turn to the UGC regulation, it's too late. I'll be very brief. That UGC regulations of 2018, it is applicable as regards the recruitment process. Page 107. This is for 2018. Table 3.A. 3A. Page 107. Criteria for shortlisting of candidates for interview for the post of assistant professor in university. For college, that table 3B. Now, table 3A. We can skip the other academic record, graduation, post-graduation, MPhil, PhD, down below. We can skip note A. For MPhil, 30 marks, JRF, 7 marks, we can skip. Now B, it is important. Number of candidates to be called for interview shall be decided by the concerned universities. So, 10 candidates have been shortlisted, including private respondent number 8 and the repeat. So, that shortlisting power has been entrusted to the university authority. Accordingly, they shortlisted 10 candidates, 3 absent out of 7, private respondent number 1, the read petitioner 2, and 1 Pallabika Sharma, 3. Now, most interestingly, Pallabika Sharma and private respondent number 8, both of them do not have any NOC, since both are probationary. I will come to the rules a little bit later. So, as per UGC regulations, which is applicable to the KK Hendricks State Open University, and as per the ordinance number 8, these NOC, requirement of NOC would be optional, directory, not mandatory. And if we come to the advertisement below, page 19 of the writ petition. Page 19, Annexure 1. Finally, similar, there is no requirement for NOC. Only applications are invited from the Indian citizen for the following post. The 6th one, 7th one, assistant professor in Assamese 1 post. Online application form with details of required qualification, scale of pay, age limit, application fee, etc. will be available at the university website, so large date friends. So this is the paper advertisement. Nowhere it has been mentioned that NOC would be required. Accordingly, number of candidates applied. Now,
This advertisement is something, but in the application form.
Miller, I will come to that. Now, my affidavit in opposition, Miller. The qualification and requirements. Since entire matter revolving around that NOC aspect, so my lord, I again focusing upon this advertisement. Annexure A, page 12, my lord, internal page 12.
No,
In-
your affidavit in opposition.
Affidavit in opposition by the
Running page-
university.
running page.
Running page 60.
Affidavit in opposition. Right, one to six. Relevant to six. Relevant. Relevant page 60.
Assistant professor, internal page 16. Essential
Your affidavit in opposition.
affidavit in opposition, internal page 16.
60. Running page 60.
Running page 60.
Oh.
60. Clause 6, assistant professor. Essential qualification, I want to reiterate, my lord, is A and B. Here also, my lord, down below, B is regarding, my lord, PhD degree obtained from foreign university. Essential qualification, and next page, note, page 61. The academic score as specified in Appendix 2, Table 3A, I have just, my lord, referred to. For universities and Appendix 2, Table 3B for colleges of the UGC Regulation 2018 shall be considered for shortlisting of the candidates for interview only, and the selection shall be based only on the performance in the interview. My lord, here, my lord, no regarding requirement of NOC, my lord, not mentioned. Now, this desirable qualification, we can skip. Now, if we come to the application level. The read petition level, Annexure 2. Annexure 2, page 20 onwards. The last page 23. General information. Since we know the advertisement was for professor, reader, as well as lecturer. For professor and reader, that experience is must, mandatory, and essential qualification. It is also as per the ordinance and as per the advertisement regarding reader and professor. But regarding lecturer, there are two types. One, fresh candidate, and other experience. So, my lord, this is general information. One, those that are already in service. I'll explain the service as regards, my lord, that private response number 8, my lord, in tune with the constitutional bench judgment, my lord. Those that are already in service shall have to apply through proportion. And now, 4. The university reserves the right to shortlist the candidates based on merit amongst the applicants. Both should be read together. And it also indicates that NOC is not mandatory, but optional. If a fresh candidate applies, then what?
It says shall.
Shall. But Supreme Court is clear, my lord, if sometimes shall or may, it does not indicate. Shall does not indicate that it is mandatory. But under the, my lord, circumstances, the factual context, my lord. So, my lord, if we read together 1 and 4, and it is general information, and the context is for reader and professor, experience is must, and so they will have to come through proportional along with that NOC. But for lecturer, there are two categories. One, fresh candidate without any experience. That is essential qualification without any experience. Desirable qualification.
From where are you saying that?
Miller, that advertisement, Miller.
What about your application form?
Miller, it is the application form. But if we come back to the, I wanted to be very brief, Miller. Anyway, Miller, that advertisement, Miller, my affidavit in opposition.
regarding qualification and requirements of professor and reader, page running page 56, 57, annexure A, Miller. The first one is professor. Miller, kindly turn to A2. A2 for professor. Miller. A minimum of 10 years of teaching experience in university college as assistant professor. So it is essential, Miller. Now, if we skip other things, Miller, we come to the other 2, 3, 4 professor, other departments, Miller. Everywhere, Miller, that essential qualification of minimum 10 years teaching experience is there. Now, if you come to reader, Miller, associate professor, 5. Internal page 15, running page 59. Running page 59, associate professor, reader. Essential qualification, 3. Yes. So, my lord, this running page 56 regarding professor, and now regarding associate professor, reader, running page 59. Essential qualification, 3. A minimum of 8 years of experience of teaching and or research in an academic research position equivalent to that of assistant professor in university, college, or accredited research institutes, etc. 5.3, Miller, page 59. So, Miller, regarding reader as well as professor, Miller, this teaching experience is a essential qualification. So, Miller, that NOC would be required and it would be mandatory for those 2 posts. But regarding this next page, 60, assistant professor, I have already stated, Miller, that there are 2 categories. One, completely fresh, Miller, candidate without any experience. Since experience is not essential qualification, desirable qualification. And second category, the candidate who has got experience in college or university. Then, Miller, that candidate would have to produce the NOC. So it's regarding mandatory and, Miller, directory aspects of NOC. Now, if we turn to the provincialization rules, education code, first, College Employees Provincialization Act, page 491. Starts from page 490. 491. Definition 2B, employee. Okay. Page 491. Definition 2B. Employee. Employee means an employee of a college, both teaching or non-teaching, appointed substantively. It is important, Miller. Appointed substantively against a sanction post. The post should be sanctioned and he should be appointed substantively. Now we can turn to page 502. 501. Rule 13. It is under Rules 2010. Rule 13, probation and confirmation. Subject to availability of a permanent vacancy in the respective cadre, a person appointed on direct recruitment shall be placed according to seniority on probation against the permanent vacancy for a period of 2 years before he is confirmed. So, a fresh appointee, he will have to go through a probationary period of 2 years as per Rule 13. And after that, he'll be confirmed. Now, if we turn to page 504, the last page of that rule, Rule 24. It is the most vital provision, Miller. No objection certificate for higher studies and applying for jobs. The governing body shall issue no objection certificate to the college employee. Now here that employee comes into Miller. For applying for admission to course of higher studies and for other things. So that employee should be substantively appointed as per definition 2B, section 2B of the Act. Now, whether probationary lecturer would be substantively appointed, it is clarified in the 5 judges constitution bench in Dhingra case. Negotiate. Since we are on that NOC requirement arena, so this is very, very important, Miller, this judgment. In PL Purushottam Lal Dhingra versus Union of India, AIR 1958, Supreme Court, case 36, para 11 and 12. Para 11. Since it's a very, very important, Miller, judgment regarding this case, Miller. So I'll read this para 11. Para 11. The appointment of a government servant to a permanent post may be substantive or on probation or on an officiating basis. 3 categories: substantive, probation, and officiate. So, Miller, this substantive appointment as regards this definition of employee, college teacher, Miller, it's distinctly, Miller, 3 categories the Supreme Court has divided. A substantive appointment to a permanent post in public service confers normally on the servant so appointed a substantive right to the post, and he becomes entitled to hold a lien on the post. This lien is defined in Fundamental Rule so and so as the title of a government servant to hold substantively a permanent post, including a tenure post, to which he has been appointed substantively. It is regarding, Miller, that substantive nature of the appointment. The government cannot terminate his service unless it is entitled to do so, 1, by virtue of a special term of the contract of employment, for example, by giving the requisite notice provided by the contract, or 2, by the rules governing the conditions of his service, for example, on attainment of age of superannuation prescribed by the rules, or on the fulfillment of the conditions for compulsory retirement, or subject to certain safeguards on the abolition of the post, or on being found guilty after a proper inquiry on notice to him of misconduct, negligence, inefficiency, or any other disqualification. This is regarding, Miller, substantive appointment. Now it is important, it is regarding probationary, Miller, appointment. An appointment to a permanent post in government service on probation means, as in the case of a person appointed by a private employer, that the servant so appointed is taken on trial. The period of probation may in some cases be for a fixed period For example, for 6 months, here, my lord, 2 years, as per Rule 13. Or for 1 year, or it may be expressed simply as on probation, without any specification of any period. Such an employment on probation, it is important. Such an employment on probation under the ordinary law of master and servant comes to an end if during or at the end of the probation the servant so appointed on trial is found unsuitable and his service is terminated by a notice. An appointment to officiate in a permanent post is usually made when the incumbent substantively holding that post is on leave or when the permanent post is vacant and no substantive appointment has yet been made to that post. It is regarding, my lord, that officiating, my lord, post, officiating appointee, my lord. Such an officiating appointment comes to an end on the return of the incumbent substantively holding the post from leave in the former case, or on a substantive appointment being made to that permanent post in the later case, or on the service of a notice of termination as agreed upon, or as may be reasonable under the ordinary law. It is therefore quite clear that appointment to a permanent post in a government service, either on probation or on an officiating basis, is, from the very nature of such employment, itself of a transitory character, and in the absence of any special contract or specific rule regulating the conditions of service, the implied term of such appointment under the ordinary law of master and servant is that it is terminable at any time. In short, it is important. In short, in the case of an appointment to a permanent post in a government service on probation or on an officiating basis, the servant so appointed does not acquire any substantive right to the post and consequently cannot complain any more than a private servant employed on probation or on an officiating basis can do if his service is terminated at any time. Now we can skip the other sentences. So, my lord, there are 3 broad categories. One, substantive appointment to the post. Another, probation. It's a private, my lord, master and servant relation and officiating basis. So, my lord, here, since he is in probationary period, only 6 months, my lord, he is in the service, my lord. And that Pallabika Sharma, both are were in probationary period. And so, my lord, NOC is not required as per this rule. And more important, my lord, aspect is that it is regarding appointment to the college, not to the university. And for university appointment, this ordinance number 8, I have already relied upon, my lord, that would be applicable in tune with UGC regulation. So shortlisting have been made. 10 candidates have been chosen, including the private respondent number 8, that Pallabika Sharma, and the writ petition. So, my lord, in view of all these aspects, my lord, it is that requirement of NOC, even in the call letter, my lord, to be, my lord, fair enough, my lord, in the call letter, it is provided that the candidate will have to bring the NOC. But in case of private respondent number 8 and Pallabika Sharma, since NOC is not required, they are in probationary period. So, my lord, as per this constitution bench judgment, it's, my lord, not
This
mandatory.
constitutional bench judgment is with regard to your lane of holding the post. That's all.
My lord, lien is regarding that substantive appointment, my lord. First 3-4 lines are important. That lien is regarding substantive appointment to the post.
Okay.
But regarding that probation,
Probation period
no
also it
lien,
says
no
that
lien
it can be terminated at any time.
anytime. It's like a private appointment. Master and servant relation is there, but not substantive appointment.
No, what has this got to do with the NOC?
I mean, since my lord, the NOC would be, my lord, provided by the college governing body to the employee, college employee. But that college employee definition is in the act. section 2B, that employee should be substantively appointed. So that appointment should be substantive, not on probation. So on probationary, employee, teacher, should not, answer into that requirement of NOC,
Okay.
And regarding, citing of the shortlisting, on the last occasion, whether these regulations, whether these 5 judges bench, these were discussed in the shortlisting process. That day, I, submitted, that Tulsiram Patel case, I beg to, submit the paragraph number 126 of that judgment, Only that parameter. It's also a constitution bench judgment, 5 judges. 1985, 3 SCC, 398. Para 126. Last 7-8 lines,
Yes.
From third line, it is also well settled, page 501, third line. It is also well settled, third line, that where a source of power exists, the exercise of such power is referable only to that source and not to some other source under which where that power exercised. The exercise of such power would be invalid and without jurisdiction. Similarly, if a source of power exists by reading together 2 provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it as an order passed under both those provisions. Further, it is applicable in our case, Further, even the mention of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists. Some cases have been referred, Supreme Court cases. The omission to mention in the impugn orders the relevant clause of the second proviso or the relevant service rule will not therefore have the effect of invalidating the orders, and the orders must be read as having been made under the applicable clause of the second proviso to Article 311(2), read with the relevant service rule. It may be mentioned that in none of the matters before us has it been contended that the disciplinary authority which passed the impugn order was not competent to do so. So, it's regarding Article 311(2), but other service rules also, the ratio is if one omits to mention the relevant provision, this Rule 24, the definition of employee, then also, if the university authority has the power to shortlisting the candidates as per their ordinance, as per their, that UGC regulation, then,
I find it difficult. How is this case applicable to the present case? I don't understand.
This is the ratio.
Ratio this, we know that in Sriram's case.
In the shortlisting, process, these provisions have not been, referred. So, on the last occasion, your lordship has queried, that whether that those provisions, Rule 24, Section 2B definition, those have been discussed in the shortlisting process by the university authorities. At that time, I submitted that as per Tulsiram Patel, it is not required. But that empowerment, that provision should be there. So that Tulsi Patel is also this ratio, though it is applicable in 311(2), the other 5 judgments of the Supreme Court also referred that if there is a provision for empowering someone to do something, it's enough.
See, Fukan, this whole case is rotating only on the issuance of only NOC.
So, since Milord, without NOC, that shortlisting has been made. So it is, Milord, last occasion, Milord, it has cropped up whether it would be legal and lawful. So, Milord, regarding mandatory and directory nature, Milord, there one judgment, Milord. I Jenny Khaidem and others, 2017 4 GLT 673. There are 18 and 19. Milord, 18 is a long Milord, para Milord. We can skip that 18, but the entire context is in para 18 Milord. Now para 19 Milord. Only this 7, 8 lines. Para 19. So far as these two cases, namely so and so are concerned, it may be noted that the qualifications prescribed in the notification dated so and so in respect of the language graduate teacher for language of so and so are 1. Graduate from a recognized university institute, and 2. Mother tongue in the concerned tribal language recognized by the board. It is nowhere mentioned in the said notification that to be eligible for appointment as a language graduate teacher, one must possess the qualification of B.Ed from recognized university institute. The requirement of a certificate of training from a recognized institute is only desirable and not an essential qualification, and therefore the question of applying the provision of the so-and-so act to the appointment of a language graduate teacher does not arise at all. The rejection of the candidatures of the petitioners herein is unreasonable, arbitrary, illegal, and the notification dated so-and-so issued by the Director of Education, Government of Manipur in respect of the petitioners herein is liable to be quashed and set aside. So, there's two Milord aspects, desirable and essential. So, essential is mandatory and this desirable is optional. So, since requirement of NOC falls under that desirable Milord qualification. So, Milord, this
Where is the desirable, where does it mention that NOC is desirable?
Milord, under the factual matrix, Milord, since Milord, the essential qualification does not indicate that experience is a must.
How do you overcome Rule 24?
That definition, Milord, that constitutes
Employees.
Milord.
That's how you want to skip.
Milord. And this is another aspect, this is for college employee, Milord,
Okay.
not for university. And another one, Milord. I'll place another judgment regarding the West Bengal Central Commission, Milord, case, Milord, 2019. Milord, there, Milord, the Supreme Court made a judgment, Milord. You refer only that judgment. In another case, I have already referred this judgment, Milord. Maybe Milord, para 30, 31, and 32. 2019, volume
Para?
18, 30, 31, 32. 2019, volume 18, SCC, page 39. May I read it? In exercise of its power of judicial review, the court is to see whether the decision impugned is vitiated by an apparent error of law. Para 30 minutes. The test to determine whether decision is vitiated by error apparent on the face of the record is whether the error is self-evident on the face of the record or whether the error requires examination or argument to establish it. If an error has to be established by a process of reasoning on points where there may reasonably be two opinions, it cannot be said to be an error on the face of the record, as held by this court in so-and-so case. If the provision of a statutory rule is reasonably capable of two or more constructions, and one construction has been adopted, the decision would not be open to interference by the writ court. It is only an obvious misinterpretation of a relevant statutory provision, or ignorance or disregard thereof, or a decision founded on reasons which are clearly wrong in law, which can be corrected by the writ court by issuance of a writ of certiorari. 31. The sweep of power under Article 226 may be wide enough to quash unreasonable orders. If a decision is so arbitrary and capricious that no reasonable person could have ever arrived at it, the same is liable to be struck down by a writ court. If the decision cannot rationally be supported by the materials on record, the same may be regarded as perverse. 32. However, the power of the court to examine the reasonableness of an order of the authorities does not enable the court to look into the sufficiency of the grounds in support of a decision to examine the merits of a decision, sitting as if in appeal over the decision. The test is not what the court considers reasonable or unreasonable, but a decision which the court thinks that no reasonable person could have taken, which has led to manifest injustice. The writ court does not interfere because a decision is not perfect. So, my lord, that decision for dispensing with the requirement of NOC in view of that constitutional bench judgment and in view of the definition of employee in section 2B, my lord, it is, my lord, clarified by this judgment, my lord. If there are two views, my lord, that NOC would be mandatory and NOC would be directory. And if it is not perverse, and if it is not statutory, my lord, applicable, my lord, then, my lord, the other view that it is not mandatory, which has been taken by the university authority. And as per this paragraph 30, 31, 32, my lord, the Supreme Court clarifies that it is acceptable in the eyes of law. I'm only focusing on that mandatoriness or directoriness of the requirement of NOC. And it is clear, my lord, from the definition of employee and from the constitutional bench judgment of P.L. Dhingra.
And what do you say to annexure 13, page 44 of the writ petition?
My lord, it's a circular regarding requirement of NOC. The two aspects, my lord, I have already, my lord, referred. One, it is applicable to college employee, not the KK Hendrik State Open University employee. One. Two, this is regarding substantive appointee. But the private respondent number 8 is a probationary. And as per Purushottam Lal Dhingra Constitution Bench, probationary, my lord, lecturer, he has not been appointed substantively. It would be, my lord, guided by that section 2B, definition of employee. Substantive appointee, then it would be applicable. Section 2B, very important, my lord. under the Act of 2005. Definition of the employee. Wrong option. Employee means an employee of a college, both teaching or non-teaching, appointed substantively. So he is in the probationary period. He cannot be appointed substantively. He's on trial. He's in like private employment, master-servant relationship.
Okay.
Most of them.
Worship, two things just I meant. I have already concluded my argument. Even that day also I said that I am neither this side nor this side. Just I am stand here to protect our rules and regulations. Our rules is very clear, Lordship. As per 24, the persons concerned have to obtain NOC, Lordship. It's a mandatory requirement. And one thing was just one submission was made. It is applicable in case of the college employee, not the KK handler. Yes, Lord, it is applicable in the college employee. As because the particular respondent was an employee of the college, so it's a mandatory provision. If he goes for higher studies and for other job, you have to obtain the NOC, Lord. This is the thing, boss. Otherwise, Purushottam Dhingra, that particular employee, in our given appointment, if Lordships direct the private respondent to produce his appointment letter, it clearly reflected, Lordship. There is no period of probation, Lordship. Against the sanction post, Lordship, advertisement was issued. It's against the sanction post, Lordship. Advertisement was issued after due procedure followed, section 5 and section 7, that particular persons were appointed. This is the procedure.
You have your appointment order? Who is that appointment order?
Not only him, any person. There is no
Let us-
provisions for probation. No, that is not.
We'll see. You are the respondent eight, isn't that?
To my management here, where the college employees has been.
See, this is the final appointment letter, Lordship. On the basis, on the strength, Lordship, he can serve up to the age of 60 years, Lordship.
I think as per my management, earlier submission, so there are 209. So, this particular reason. The provisionary period for 2 years. And as per service, students, all the substantive appointment, all the sanction post appointment. It helps provisional. They will have to go through the 6 months, 1 year or 2 years.
Next 18,
Page
167 of my agreement position.
No, you have college appointment.
Yes, that is one.
My appointment.
You furnish a copy of your appointment order in that, what college was that?
Positive college. Positive schools.
Hmm.
Yes.
Only that. I think arguments are over. No more. I don't need your reply.
I have spoken to some citizens also. That will be taken into consideration. Citizens. Some citizens also.
Citations. Okay.
This one is I've given a data person. This one.
The synopsis was
What?
Oh, so it's a synopsis.
Yes, sir.
Yes.
Eight citizens.
Heard Mr. R. Furkan, then the council. Also heard K. Goel and the Standing Council of Higher Education for the respondents 6 and 7. No, P.G. Furkan, then the Standing Council for the KK Hendik State Open Universities. Mr. K. Goel and the Standing Council for the respondents 6 and 7. Stop. The same. Oh.
6 is different than my.
Is it?
1, 2, 6, 1, 2, 3, 4, 5, and 6 by. I am for only 7. 7 and 9 was 7 and 9. 7 and 9.
What you call this? PG Furkan, Standing Council for the respondents 1, 2, 3, 4, 5, 6. Mr. K. Uber for the respondents 7 and 9.
7 and 9. And the next for A substitute.
Mr. S.M. Barwa, Learned Council appearing for the respondent number 8 shall produce the appointment order of the respondent number 8 in the
Positive school.
in the British College, no? British College. What? When can you produce?
Friday. Friday.
Coming Friday?
Yes.
Or tomorrow?
Tomorrow.
Tomorrow is also Friday.
Yes, I can notice.
Can you produce by tomorrow? Or we'll give you a longer date someday.
Next week.
Next week will be better.
Monday. Monday.
Maybe it be 20 Tuesday on a hearing. 20, let's say. On 21. Obliged. Only that appointment order in that, not this handy. Practice. Obliged. And if you can find out also, you can also find. Lordship. I think my case is already given the other point is that ODL expense, I think he was given marks, Lordship. No, that's a different issue. Lordship, not. Just see if you can get the upper. Lordship, that's why I'm trying. Obliged.
Item 40. Item 14 lordship on last second I was there to find an affidavit and I couldn't find it lordships. Lordship may kindly fix it next week. I'll find it by Wednesday next lordship.
There's several location lordship here.
There's no several occasion lordship. In fact, if I am agree lordship, in fact that order was itself was lordship was wrongly obtained lordship. There should have been obtained against that director of secondary education lordship. Anyway, let me file an affidavit. I'll explain everything lordship. And it should be leased along with WPC number lordships.
Yes.
1126 of 2024, which is disposed of lordships. That may be recorded.
On the next.
Mr. M. Khan, Learned Counsel for the petition. Mr. SMG Chishti, Learned Counsel for the sole respondent.
Yes.
It's allowed 1 week time.
1 week, yes.
To file affidavit. List the matter on
Next Thursday, Lordship.
Next Friday.
26th May. Along with WBC 1126 of 2024. which was disposed of on 4/3/2020. Correct?
Yes.
Worship can be on 27, Worship. 27.
Item 16, hearing.
15 to time only, Nikki. Huh? Mention me.
My lord, in this case, I'm appearing for the respondent as an amicus, my lord. On the last occasion, Lordship had heard the matter. And today, your Lordship has fixed it for submission of the written argument. I'm sorry, my lord, I could not prepare. I may be granted just 2 days' time. On next Tuesday, I'll definitely produce. And in the meantime,
Heard Mr. P.K. Roy, learned senior counsel, assisted by MS
A Chakraborty.
A. Chakravarti, learned counsel for the on request made by S. Chakravarti. Learned amicus curiae for the respondent number 2. When do you want?
Tuesday, my lord, that day, Lordship will.
I'm filing it today, my lord.
You keep it.
All right.
Something it goes.
All right, all right.
Tuesday,
Tuesday,
20.
20.
Because
Because on that day, both the parties will submit the written argument.
20. Is it convenient?
yes, sir.
Okay.
Tuesday, third? Tuesday,
Tuesday.
20.
Cool.
20th.
oh, yes.
I'd like
17.
My lord, in this case, Mr. Gogoi has made submission on behalf of the respondent number 3. And there are some private respondents. They will argument, then I'll make my submission.
6, 7, 8, and 9.
6, 7.
Today also 10 is not present.
I
E.G. Fukan. You have for respondent number 10? Okay. You are Mr. A.K. Azad.
my lord.
Yeah.
I am for the respondent number 6, 7, 8, and 9, my lord. The legal argument of learned council, learned Eastern Council of Higher Education, my lord. I have adopted legal part. I have adopted, my lord. Other actual part, my lord. I have to say, Lordship will find is 35 repair portion of the repetition, my lord. 35, my lord. I am reading, my lord. In the premises above said, it is therefore felt that your lordship would be pleased to admit this petition, call for the records, issue rule, calling upon the respondent to show cause as to why it in the nature of certiorari shall not be issued to set aside the course the impugned letter dated Songso dated Songso, exam 19, my lord. Another 19, my lord. What is another 19? Now I am coming another 19, my lord.
Page 79.
Page another 19, page 79. Page 79 and para 11. Para 11, my lord. I am giving para 11.
Para 11?
Para 11.
Of the
petition, man. And the petitioner begs to state that the Director of Higher Education Assam has issued the impugned letter by number Songso dated Songso, whereby the vacant post of English Department of West Gwalior College has been blocked and proposal has been submitted for adjustment of the said post against the Department of Political Science. It is pertinent to mention that the petitioner has not
petitioner has been appointed in the non-sanctioned post of English department of the said college, and he has been continuously working in the said post since his appointment dated 15/12/2003. Since his service has not been regularized, the vacant post of English department cannot be blocked for adjustment of the post of political science department. On the other hand, two number of vacant posts are also available in the Department of Political Science, and therefore the private student number 6 working in the Political Science department in the same college by may be adjusted against the vacant post of his own department. However, the two vacant posts of Political Science department have been blocked against the Department of Geography and Economics of the same college for adjustment regularizing. Thus, the vacant post of English department against who is the petitioner has been working has been illegally blocked by the impugned letter dated 9/1/2017, and process has been initiated to adjust / regularize the service of the private restaurant number 6 against the said post of English department. Therefore, the process of regularization adjustment of the post of private respondent may kindly be stayed, or otherwise a direction may be issued to the official respondent restraining them to adjust any person against the vacant post in the Department of English of West Goalpara College in the interest of justice. Now, my lord, come to the letter dated 9/1/17, my lord. It is page 17 as well. With the reference to the cited above, I have the honor to submit proposal for according approval for filling up 272 number of vacant sanctioned post of assistant professor of different provincialized colleges of Assam as per Form 1 and 2 for favor of kind information and necessary approval of the government. In this regard, it may be stated that the proposal for according permission for 396 number of post of assistant professor have been submitted to the government by office letter dated so dated as so out of 396 have been blocked. Not only petitioner, my lord, out of 396, 61 number posts have been blocked. Those who are working non-sanctioned post, and they have no subject concurrence, my lord. Petitioner post subject concurrence was not there, my lord. That is the main issue, my lord. Have been blocked from the college where non-sanctioned teachers are working. 63 posts have been blocked from other colleges. Even where there is no non-sanctioned teachers, where PTR is found so. Remaining 43 posts will be blocked from the out of next phase of vacancy when submitted. As such, in this phase of out of 166 posts to be blocked, 61 plus 63, 124 posts have been blocked. Government may agree to this proposal since the colleges are suffering and allow this and approval to 72 posts as per the format A and B, my lord. Then his posts have been blocked, not only his post, my lord. Total 167 posts have been blocked. Those who are working non-sanctioned post, my lord. Thereafter, my lord, another prayer. There is final sanitary list dated 24/4/2010, my lord. Another 26. Final sanitary list, my lord. There is another 27. His name was not there, my lord. He challenged this final sanitary list without implementing the selected candidate, my lord. our 6, 7, 8, and 9, they are in the final seniority list, my lord. They included us as a respondent, but entire list should be made party respondent. My lord. And this was final seniority list was published 2010, my lord. And petitioner, my lord, filed the petition after 8 years later, my lord. 2018, he filed his petition, my lord. And final seniority list was prepared on the basis of office memorandum 2010, my lord. But this office memorandum has not been challenged in this petition, my lord. And another prayer, my lord.
OM dated
OM dated 17/7/2004. Pursuant to this OM, my
where is
lord.
that OM?
My lord. OM, my lord, 114, page number.
Page
Page 114, my lord.
114. Yeah.
One one four. Lordship will find 115 para 4 subpara C, my lord. What is, my lord? Para C. To accommodate the teachers working without sanction post in a college where there is no vacant sanction post, or where the number of vacant sanction post is less than the number of teachers proposed to be adjusted in conformity with the OM, the director higher education is authorized to withdraw the vacant post. My lord, it is important, withdraw the vacant post from a deficit grant in 8 colleges where student enroll or other norms do not justify to the total number of the sanction post in that college. The director higher education will prepare a list of such vacant withdrawal posts from different colleges giving necessary details. Thereafter, he will consider the cases of all those teachers working without sanction posts and appointed as per procedure as mentioned in para 4 above, in order to your seniority list of services for adjustment and send such proposal to the government for approval. However, if a vacant sanction post is available in a particular college for adjustment for such post against any eligible teachers working without a sanction post in the college, no additional allotment of post will be made to such college. This is the, my lord. Other prayer.
Okay, we'll resume it.
My lord.
Item 70.
Another pair, my lord. Annexure 30, letter dated 12/9, page, my lord, 118. 118, my lord. Time for setting aside this letter, my lord. 118, my lord. This is para 22. The statement made para 22. I'm reading, my lord, 22, para 22. Married, my lord. That the petitioner begs to state that in the letter by number so-and-so, dated so-and-so, 12/9/2017, issued by the Director of the Higher Education Assam to the Principal Secretary to the Government of Assam, Higher Education Department. It is reflected that the government may restrict it to regularize the service of those teachers only whose names have been included in the list of 354 numbers of college teachers. As such, the petitioner's service may not be regularized in future if the government is not restrained to allot the post of English department to the private restaurant number 6. And private restaurant number 6, his post has not been provincialized till now.
Private respondent 6, not yet provincialized.
Not provincialized. And respondent number 7 have been provincialized 2018. And
Respondent 7. What is the date of provincialization?
provincialized, my lord. I have filed affidavit in this area, my lord. 12 for sorry.
Who's the order?
Seven.
What's your affidavit in opposition?
My lord. File on 4/1/2022, my lord. 25/4/2018, my lord.
Page.
Page 24. Annexure
No,
E.
running page. Your affidavit in opposition.
Opposition. Annexure E, page 24.
What's your affidavit in opposition?
Affidavit filed, my lord, on 4/1/2022, my lord.
Respondent number 7.
Respondent number 7, my lord. Got it, my lord?
Yes.
My post, my lord.
Which?
It's Nityamoni Nath. This is my appointment, my lord. Page 24.
No, give the running page.
Page 24 in my affidavit, my lord.
Give the running page. Nityamoni. Okay.
11. 111. Come on.
At my post, my lord, then lordship will come page 21 in my affidavit, my lord.
No, this is your regularization order.
Yes, my lord. This post have been withdrawn from Guwahati Commerce College.
Yes.
And respondent number 8, my lord, his post has not been provincialized till now. He's working as assistant professor of economics department, my lord. And respondent number 9, my lord, his post have been provincialized on 25/4/2018.
Where is that?
Gagan Chandra Nath, my lord.
Where is that order? Order.
Order, my lord. This affidavit has not been filed, my lord. This, I have the order, my lord.
You have not filed affidavit.
My
Respond number 9.
9, my lord. No file, my lord.
Okay.
And this appointment.
Where is that order? Okay.
Respondent number 7, filed by affidavit filed on 4/1/22.
It's para 11, my lord, in the affidavit, my lord.
Yeah.
What was the procedure for province slash, my lord? That is stated in my affidavit, my lord. 11, that with regards to the statement made in paragraph number 22 of the writ petition, the deponent begs to state that the process of regulation of 99 number of assistant professor plus lecturer working in non-sanctioned post had been started long ago, and Director of Higher Education Assam recommended 99 number of post for giving the same whenever necessary by its letter proposed dated 12/9/2017 to the government. Following this, the Joint Secretary Higher Education Department, Assam, by his communication bearing number so dated 29/12/2017, conveyed the approval of the government for regularization of the service of 99 lecturers of different colleges against the vacant sanction post in terms of the seniority list dated 22/4/2010. In seniority list, I have my name is there, my lord. Then lawsuit will come para 12, my lord. That the deponent begs to submit that on the government approval dated 29/12/2017, the Director of Higher Education Assam sent a letter to the government on 31/2018 by categorizing the post into 3 categories. That is 17 number to be regularized within the same department. Number 2, 50 numbers to be regularized in the same college but other department. It is the policy decision by the government. Number 3, 32 number to be regularized by withdrawing post from other college. That is section number 7. His post have been withdrawn from Guwahati Commerce College. And arguing approval of this mode, the deponent fell under the 3rd category. That is section number 7. On 25/4/2018, Director of Higher Education Assam issued a letter by which the service of the deponent has been regularized with fixed pay in the West Goalpara College. This is number 7, ma'am. And my lord, petitioner, mainly my lord, petitioner post has not been regularized because without subject concurrent, and no on could be province line.
No, without the concurrence of the government.
My lord. Yes, ma'am. It is mandatory, my lord. As well, his post has not been province line. And my lord, judgment which submitted by the Learned Standing Council Higher Division, my lord, I have relied those judgment, my lord. And this is my submission, my lord. Response number 7 and response number 9. Their posts have been provincialized, but the petitioner have not challenged this appointment, my lord. And 6 and response number 8, my lord, their posts have not been provincialized till now, my lord. Learned Senior, my lord, prepare response for response number 10. And we will do.
Yes.
My lord, my affidavit in opposition, my lord.
Where is that?
Respondent number 10.
You have the running page.
My lord, I'm sorry, my lord, I don't have the running page number. Respondent number 10.
When did you file it?
My lord, on 6th February 23, my lord.
Azad, the respondent number 6 and 7 has filed affidavit. 8 and 9 has not filed, is it correct?
9, yes, Lordship, I filed IA. In IA, there is an order, my lord, on
No, 8 and 9 has not filed. I just want to be clear, that's all.
yes, yes.
8 and 9 has not filed. And 10 has filed. Fuka?
Yes.
That's affidavit is not only for. Just check up.
Very small affidavit, my lord, but
No, here's the index, no. Audio petition, I mean,
someone have not put it. No.
just check here. Because here the thing should be there, no. Here it's not written. You've got a copy?
My lord, we have also not received the copy, man. Recently.
Fukan, it is not on record.
Devoni Kumar side.
In the index, it is not there. No, this is in the IA, no. This is not by the respondent number 10.
Index it is not there, Lordship. Index not there, Lordship. In the index.
Yeah, you're correct. It's not there in the index, it is not there.
Nothing. No. Time will be challenged. Saya mau ini jadi kata ini saya mau pikir aku pikir apa itu
Give the date when you filed it.
6/2/23.
6/2/23.
6 February 23.
একদম full।
আমি কপি নকৰিলে ৰেকৰ্ডত থাকিব লাগিছে। মই কিবা কাৰণত দিবই লাগিছিল। কিবা কাৰণত ৰেকৰ্ডতে অহা নাই।
মই হেৰি কৰিম, দেৰি নকৰোঁ আৰু, দেৰি নকৰোঁ। I'll submit on your legal provision part. Very short affidavit it was.
You will let it come on report.
6 February 2023.
6/6/23. 23, madam, 23 affidavit should be on report. Is it in the defective stage?
My lord, don't have the.
Price of the sometimes.
Only 4 pages, 5 pages, 4 pages.
Mr. A.R. heard Mr. A.R. Shikar and the concept of the homework. Also heard Mr. A. Gober and a standing council higher education department. And Mr. A.K. Azad and the council. Para. Mr. P.G. Fukan and the council appearing for the response of the submits that we are spelling out on 6/22. Register to verify and post the summary. We'll give them 1 week time because registry is quite busy. List.
I may be served a copy.
You serve a copy also.
Want to take this to
We'll have it on 27th. Okay.
Tuesday.
Is a hearing date.
Most of it. 27. 27.
Development.
Item 19.
This is relating to one of sanction of medical leave, leave of increment, etc. madam. The petitioner was working as subject teacher in mathematics. Presently, he is working at Aadhar Higher Secondary School. He is working as my lord subject teacher of mathematics in Aadharshan Higher Secondary School.
Aadharshan.
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 ADHAR, Aadhar, CHAMD, Aadharshan High School. No, my lord, he was appointed, my lord. He was appointed as subject teacher, my lord. Initially, my lord, page 24, no, page 25. Type copy is page 26. No. Annexure 1, page 21, madam. His initial appointment was on 8th of November 94. As subject teacher in mathematics. Page 21. November 94, he was appointed as subject teacher. Temporarily, thereafter his service was regular as my lord.
As subject teacher.
Mathematics.
Where is that?
Subject to discharge without notice and without assigning, page 21, my lord. Any reason thereof, see Nila Datta care of so so supposed to be Silchar subject is hereby appointed as temporarily as subject teacher in mathematics.
What date is this? 30?
8 November 1994. 21, page 21, annexure 1. 8 November 1994.
RCBB.
Yes. Thanks. Next page, page 22. That on the basis of it is minor dated 38 August 2001. On the basis of the screening conducted in Toronto, under Toronto, appointment of Srimati subject teacher so-and-so, that was appointed on so-and-so, is hereby regularized. Regularized on 38 August 2001. My lord, he has fallen ill, my lord. Not, he has got heart attack in the school. That my lord did regarding this page 23, that the following employees so-and-so, and they were as are hereby granted leave for the period with effect from the noted as against each below. Second number is Nila Datta, the petitioner. The in persons of the leave on duty is hereby granted to so-and-so of the person for the period of 35 days with effect from 15/3/2006 to 18/4/2006 at CMC Vellore for treatment for open heart surgery. This period was my lord regularized. Leave was regularized by the inspector, assistant inspector of school CPC.
This is a regularization order? No.
Regulation order was 38 August, Annexure 2.
No,
Service, service.
Your leave regularization.
Leave, a small period was regularized. Thereafter, what happened, my lord? He got again and again heart attack. He joined school, again he got heart attack. So, my lord, this subsequent period, my lord, the principal did not forward the leave application. As a result, my lord, this leave was not sanctioned. Although he joined, almost, my lord, from 2006 to 2012, he was on leave and he has got three heart attacks, open heart surgery also. Thereafter, he is fully cured. After he was in a distant place, his posting was distant place, he filed a writ petition in the Honorable High Court and a very nice order was given. Accordingly, he was posted in a nearby school and he's still presently working as mathematics teacher. But my lord, the leave period, the application which was not forwarded by the head principal, that could not be my lord sanctioned. Number one.
How long is your leave?
Yes, all these are leave period. Yes, my lord.
The leave period that has not been sanctioned.
Not been sanctioned. Again, for 80 days, page 26. It was sanctioned, my lord. That small portion, page 26, combined leave, unleave on MC for a period of 80 days with effect from 1/3/2006 to 14/3/2014 days, 19/4/6 to 23/6 66 days, and leave not due 7 days with effect from so-and-so under rule so-and-so and not so-and-so. Amended is hereby granted to see Nila Datta, repetition. Some portion was granted, page 26. The inspector of schools granted the possibility of his returning to the post from which he proceeded on leave. Some portion was granted. Now I'm coming to my lord. It is my lord, page 28, Silchar Medical College, he was admitted. Discharge notice, my lord. Thereafter, all these lease application, medical certificate, discharge summary from Christian Medical College, Vellore also. So he was undergoing in different places, Silchar and Hello. Many applications, lesson discussed in South City of. Ultimately, what happened, my lord?
Where's your application for leave?
A bunch of petitions I have enclosed here, my lord. First, medical certificate from page 28 onwards to my lord. To my lord. It's 40, 41, 42. Up to 42, my lord. From page 28 to page 42, my lord. All these are, my lord, medical certificate, discharge certificate, etc. He was admitted in different hospital, particularly in Silchar Medical College and the Vellore Christian Hospital and one South City Hospital. Therefore, his leave application started page 43 onwards, my lord. Page 43, Annexure 7, that prayer for extraordinary leave with effect from August 22 September 7 under medical ground. From that, I am not in a position to attend the school due to my illness and post-operative complications. I therefore request you to grant me extraordinary leave for those days, the act of which I shall remain grateful to you. Therefore, again, my lord, this is dated, my lord, 38 August 2006. Therefore, again, 27/9/2006. Several years is apart. So all this leave application from time to time continued till, my lord, till page 76. Page 75, prayer for extension of leave on medical ground. So total 6 years he could not attend school. And he went to, my lord, 3 times heart attack and followed by surgery also, open surgery. So sometimes it happened, my lord, God is there, but sometimes some people suffer. But thereafter joining at, my lord, in 2012, till now it is 25, my lord, by the grace of God, he is continuing well in the school. But, my lord, this part he has to approach this honorable court for non-sanction of this period and non-forwarding by the principal of that time. He died now. The principal is no more, so I cannot make him party. The on order, my lord, at Annexure 8, page
No,
77.
principal, you don't have a principal of the
No,
school?
your lordship.
No.
I
He
would
died,
like
my
to
lord.
give objection, your lordship. in
Yes,
this
yes, later on start. Let me finish first. So the principal who did not forward, he died, my lord. So
No,
the
that's a particular person.
particular person died.
But then after he died, someone must have taken
Now,
charge.
my
of-
lord, he is not working in that school. He is working in some other school. After 12, my lord, this honorable court passed that order, my lord.
Who is that order passed by
Yes,
this
my
court?
lord, I'm placing it. Now we'll just this it. Second different. To place him in suitable place to continue.
No, when you got sick, that
Yes.
was from 2006 to
12.
2012.
Yes.
You were in which school? That
RCBB. Let
RCBB
me
school.
check, my lord. That's it. RC.
RCBPHS.
Correct.
Yes.
Now
The
you are in,
present principal has nothing to do. Because, my lord, he is no longer working in that school. And, my
That's
lord,
fine.
particular person is died.
when you were working in that RCPB school,
Yes, ma'am.
that's when you suffered the stroke and all
Yes.
this, and you suffered a lot
Yes,
from 2006 to 2012.
yes,
That period, you made the application for leave
yes.
before the principal of that school, correct?
School, yes,
Correct.
yes.
That principal should be made a party in this petition.
4-5 years back, he died. Before filing the
No.
repetition, he's died.
That person may have died, but the
Okay, my lord.
post of principal is always
That
there, no?
school, your lordship.
That post of principal is there.
Hmm.
So if you have met an application those applications would be in the office file.
Should be,
Should be. So
but.
the principal of that, what you call RCTP school, at least he should be met a party
And
so
you-
that he can give an opportunity of.
Since he has died, I did not make a party, number one.
And your lordship,
That is
Number
the-
one.
That is the
Number two
person
is not
holding.
responsible.
and your lordship, to
Number
that
two is
post,
not
your lordship,
responsible.
since he is holding that records, your lordship, that principal is holding that records. Some of the part, your lordship, we are not able to give reply, your lordship, that period, because no documents has been annexed, only simply written in annexure 7, your lordship, that is page 43. We can clearly, visibly can be able to see in that to the inspector of schools, no, nothing medical report has been annexed. Prayer for extraordinary leave with effects from 1st August to 1st August 22 September 2006 under medical ground. I have the honor, I would like to read it, your lordship. Sir, I have the
That's
honor
fine,
to,
just-
let me complete, your lordship.
It is-
I have the honor to inform you that I am not in a position to attend the school due to my illness. What illness? He has nothing mentioned it. And post-operative complication. What post-operative complication? He does not.
Okay, that's fine.
He has submitted all the records, my lord, earlier. So say, although he is continuing the same disease.
And my
each
affidavit
time an application.
take a
he needs
clear
not
stand, your
enclose all.
lordship.
He need not enclose all the, my lord, all
We have taken clear
all
steps.
the seniors, my lord, know about his, my lord, illness and admitting in the hospital. So in each application, that is not necessary to give no.
And principal is a very, because your lordship from the very first objection I have, your lordship, he was not forwarded that.
1
he-
minute, 1 minute.
That's it.
Yes.
Yes, ma'am. So that is the factual part, my lord, that whether at my lord it is 25. I filed this repetition, I think my lord in 23. So that records, because principal has gone, this person also not working in that school. Everything has left. And that person, particular person, I would have made him party, but 5 years back, he has also expired. So my lord, dead person cannot be made party. New person, several persons have been sent as principal, because it gets 2-3 years, my lord. So my lord, the present principal, he is only in the trouble because he won't be able to trace the record. He won't be able to reply what happened. Because if that person would have been alive, he would have asked that person what happened that time. But since before filing the repetition, that person expired. So there is no, my lord, possibility of getting anything.
Your lordship,
Because
kindly,
most of the persons
direction
are
may be
not-
given, your lordship, to make a party, that principal, your lordship, because.
Present principal.
Present principal, present principal, because he is holding the records, he is holding the records, your lordship. It may get changed, your lordship, but,
I
but,
can make
but the
party, there is
post,
no.
but the post
There is no-
itself is a permanent one,
Whether
your
he will be
lordship.
able to.
And
fulfill
your
it,
lordship,
verify.
on the very first objection of mine is that she made that thing very clearly submitted that that the documents has not forwarded by principal. So here, your lordship, what has their stand, your lordship? Principal has to take
Try to
his
be practical. Try to be practical.
no, your
I'll
lordship.
get
No,
instruction
your
how many
or else,
principal-
your lordship, I am
Kindly, no,
going-
no, I have not completed my submission. Please stop it now.
your lordship,
I
I
can't
am
do it
also submitting
because-
something,
because
something.
So
your
many
lordship.
principal has been sent, 2-3 principal has been sent. So now the present principal, whether he will be able to give a
That is
satisfactory
doubt, your
reply.
lordship.
Why he has not It is his personal ground.
Sakya,
Personal discussion.
Sakya,
Yes.
the issue is this.
Yes.
If the principal is not made a party, then this court may not be able to give an effective order. And the only option that this court can come to a thing is directly to file a representation before the director so and so
I'll make the present principal a party, no problem.
through proper channel,
Yes.
annexing all your documents, and then the director can take a decision in the matter. That part only we can do it. But if you want an effective order, then
Present principal has to make a party.
not by person,
Yes.
but the principle, just the principle.
Principal, yes.
Not by person.
As I know, 3 or 4 principal has been changed. Sales means retired.
No, just say the principal of so and so college.
principal. Okay.
If that is thing, then we can see
Yes.
if we can help you, because we understand
So
that you
is-
have gone through a lot of trouble,
Yes, ma'am.
heart attack 2-3 times.
Yes.
So
So,
it's your choice.
Inspector-
If you want to make principal a party, fine. Otherwise, we can dispose of this matter, directing you to file a representation before the director
That my
by annexing all your documents.
my lord, let the principal make party. She will get the instruction.
Okay, MS and Sakya.
Or lordship can also, on my request, your lordship can also add him as a party. the
Principal, we
necessary
cannot
party.
take,
Or otherwise, I'll file an implement.
You'll have to file an
implement
implement.
application.
we cannot take notice, your lordship, that is goes to private, your lordship.
That's why,
No.
that's later file the
Yes, your
implementation.
lordship.
After that, we'll
Yes,
take
your
step.
No, you have- The education department will take notice because I am not making as a,
No, your lordship,
By name.
education cannot,
By name.
education cannot take.
Principal notice has to go.
Principal, it
Oh,
goes
it will go.
privately.
MS
I'll
and
make a
Sakya
application.
Leonard Council for the petition. Praise for filing an appropriate application for infliction of necessary parties. Wow. Hmm? Praise the Lord. How long will you take? 1 week will do?
yes, ma'am, next Monday, next Monday, today is my lord Thursday.
I'll give you
Let
list,
it come
list,
Wednesday.
list
Wednesday.
after 1 week.
When Wednesday, as order column, in the order column. Otherwise, it will come again in hearing column.
Yeah.
Next Wednesday, we'll discuss. I'll file tomorrow itself.
You can file tomorrow. Next matter.
Wednesday, next Wednesday.
The first May,
Okay, man.
the order call. Huh?
Order column. Obligement.
Come give you the list.
Hmm.